thanks very much for joining this webinar on the latest issues for partnership agreements, specifically GP partnership agreements, which is what I spend all my time doing. My name's Oliver Poole. I've looked down the list, delighted to see so many of you joining, and I know many of you already, but for those I haven't met, this is who I am. I'm a partnership specialist, so I spend 100% of my time advising GP partnerships and occasionally GPs in their personal capacities. I'm part of a wider team at VWV. We're quite a big firm. We've got offices throughout the south of England, Bristol, London, Birmingham, Watford. And we merged in 2017 with a firm called Lockhart's, who many of you will know, who are also specialists in primary care. Between us, the two firms, we reckon we've acted for over 2,000 GP practices, which is about a quarter of all the practices that there are. So hopefully we know what we're talking about. As I say, I just deal with the partnership side of things, but I'm part of a wider team. Ben Willis is head of healthcare here. He's a property lawyer. He deals with the surgery development work, the lease work, anything to do with surgery premises. Rachel Crean is a litigation partner, deals with partnership disputes. She's also very good on matters related to the CQC and regulatory work. We have all sorts of other specialists, employment specialists, and so on. So that's what we say when we say we're a full service law firm. We reckon we've got the whole thing covered. Anyway, that's why I'm talking today. But what am I going to be talking about? Well, the next slide sets that out. I spend a large proportion of my time drawing up GP partnership agreements. So why do I exist? What's the point of a GP partnership agreement? Why should everyone have one and keep it up to date? I'm going to talk about premises ownership and leases and the difficult issues that can arise there if not everyone's in the same boat in the partnership. Primary care gets messed around with and adjusted and changed all the time, and lots of those changes need to be reflected in partnership deeds. So I'm going to talk a bit about clauses that need to be added in the last few years, particularly the last man standing clause. One of these things that some people say everyone must have a last man standing clause. I disagree. It's right for some, but not for many. And I'm going to finish by talking about non-GP partners. We're seeing loads of non-GPs become partners at the moment, and there are a few issues to go over there. I'm probably not going to talk about incorporation of GP practices, because I don't think we'll have time, and I do want to leave some time for questions. On the assumption that we don't get to that, the take-home point about incorporation is we can't really at the moment. It is just about possible to incorporate a GP practice, but it's very difficult, and in most cases it's not worth it anyway. Let's see if we get to that though. So for next slide, importance of the partnership deed. Why do we have them? Often when you ask people why have a contract, because a partnership agreement is just a type of contract, people will say, well, you have a contract so that you can sue someone if they don't keep up their side of the bargain. And that is one reason, but so few contracts ever get sued on. I think it's not a very important reason. That the most important reason for having a contract is that it's the product of a conversation. If you do a deal with someone, whether that's a deal to go into partnership or any sort of commercial deal in the world, you have a meeting of minds. You both get on the same page, no pun intended. And once you've had that meeting of minds, if you then record that to show what you agree, then you may well never need to look at that agreement again, because, excuse me, the vast majority of sane adults will do what they agreed to do. That's generally the way the world works. So the important thing is to make sure that people have that conversation in the first place, so that it can be written down. I mean, a vast proportion of the disputes that we see arise from misunderstandings between the partners. Partner A thought X was the deal, and partner B thought Y was the deal. And a dispute arises from that. If they properly discuss the terms of their business relationship first, then that dispute might never have arisen. And I just find at base, so many of the disputes we see come down to failure of communication between the partners. And those of you on the webinar who are practice managers, anything that you can do to get the partners communicating better makes it that much less likely that they will need our partnership dispute services in the first place. But more literally, why do you need a partnership deed? Well, it's a document which contains all the rights and responsibilities which the partners have agreed to be bound by. And it's not true to say that if they have no partnership agreement, then no rules apply. If they have no partnership agreement, there are certain rules that apply, and those rules are set out in the Partnership Act 1890. And I've listed these on the next slide. If you don't have a partnership deed, these are the sorts of things that the law says, the background law says are the case. All profits split equally, unless otherwise agreed. Well, normally you can find an agreement to the contrary if the partners work different sessions, for example. But if you don't have a partnership deed, you're what's known as a partnership at will, the least stable business structure known to mankind, because any partner at any time can dissolve it straight away. It takes effect immediately. And on dissolution, what should happen is the business is wound up, and the proceeds, if there are any, are distributed between the partners, which means the end of the practice if someone decides to dissolve. So really can be quite unhelpful. And often if there's a partnership dispute and no binding deed, someone will have someone else over a barrel because they can say, well, give me what I want, or I will dissolve. On dissolution, all the practices contracts come to an end. That would include the GMS contract, which can go out to tender. And so it's not a very stable position for a business to be in. But other things that the 1890 Act says is that there's no right to retire. You can only, you can only dissolve the practice. And the big one is that there's no right to expel from a partnership at will. So if you've not got a partnership deed, someone could get struck off and you wouldn't be able to expel them. You might have to pay them off if they didn't go of their own volition. Or if you've got a probationary partner who hasn't signed a partnership deed, how do you get rid of them if the probation doesn't work out? Because you can't ask them to leave. So not a very good position to be in. Now, there'll be plenty of you on the webinar thinking, well, that's fine because we've got a partnership agreement and it's signed. And many of you will be right, which is good. But it's actually quite easy to find yourself without a partnership deed without realizing it. And I'll tell you how. Well, I'll tell you the good news first, which is that if you've got a signed partnership agreement, all the current partners have signed it, if one of those leaves, you don't need to do anything to the partnership agreement. There's no need to incur legal fees on signing it again. The vast majority of partnership agreements, if they're properly drawn up, will say that if you've got 5 partners and one of them leaves in whatever way, then that document will continue to bind the other 4 partners. Yes, that departed partner's name will be on the front, but that's just an issue of tidiness. It doesn't give that ex-partner any new rights or responsibilities once they've gone. So when a partner leaves, there's nothing really to do to the partnership deed. But it's very different when a partner joins. If a partner joins the partnership without signing the deed, then the whole thing can fall away. And there's case law going back to the 50s showing that, for example, 3 partners have a partnership deed and they sign it. A new partner joins and doesn't sign. and the old agreements binds no one anymore, not even the three who signed it. So when a new partner joins, you must get the deed signed on or before the day the new partner joins. So a very common mistake, don't make this mistake. Don't let the partners say, oh, we'll sign a new partnership deed once the new partner gets through their probation. Don't do that. Because if that probation is unsuccessful, how are you going to get rid of them? You're a partnership at will. And you might have to pay the probationer to make them go away if it's not successful. So without a partnership deed, you can't enforce the probation, because the partnership deed is the thing that says if the probation is unsuccessful, you will go on 1 month's notice. But you also can't enforce anything else really without the partnership deed in place if a new partner has joined and not signed anything. So any other problems which might be triggered by the new dynamic that has arisen from the new partner joining, you may be stuffed on trying to enforce any of the other provisions of the deed in the meantime. So not a good position to be in. Sometimes people try to get around this by having an offer letter to the new partner. I'm not a fan of that, because if you need a contract which sets out the whole bit, that all the terms of the business relationship, and that contract is the partnership deed. Why would you only have a letter which contains some of those terms? It just creates uncertainty. So best practice when you have a new partner is to get them to sign the deed on or before the date they join. And some of you may be thinking, well, he's just saying that because he sells partnership deeds. And yes, I do sell partnership deeds, but you don't have to incur legal fees on this. You take a new partner, just update the old deed, just change the names at the top, sign it again. Much better to have, you will then have a slightly out of date partnership deed, but much better that than being a partnership at will. Moving on, I'm seeing, just as an aside, I'm seeing quite a lot of new partners joining practices at the moment. And it doesn't chime well with what we sometimes see in GP Online and Pulse. But we've, solicitors who specialise in acting for GPs have been dealing with a lot of new partnership agreements and deeds of adherence for new partners, which is slightly surprising given how difficult some things are at the moment. I guess the golden hello is having some effect, but probably more so is the fact that profits for partners are up. Now, of course, workloads are up as well. But we always tend to find that recruitment is better the more that there's a disparity between what partners take home and what salaried GPs take home, the more incentive there is to take on the additional management responsibility. And at the moment, that seems to be quite strong. There are practices who I've spoken to who are very pessimistic about being able to be able to find a new partner, and then found they had 3 or 4 really good candidates when they finally applied. So don't necessarily be pessimistic about recruitment. There are many practices that there are still candidates out there. Now, moving on to the next slide, one of the things that sometimes puts new partners off is being asked to buy into the building. You sometimes hear new partners saying, well, it's much better to have a lease. I only want to join a leasehold practice. Now, is that right? I'm not sure it is. And I think it's beholden on, well, particularly those who are in freehold practices, to put new candidates, new partners right about that. There's sometimes a misapprehension that there is no risk in a lease. Well, there is. A lease is a contract to pay rent for the remainder of the term. And once you sign a lease, you are bound to pay rent throughout. Say it's a 20-year lease. You are bound to pay rent throughout those 20 years. Now, in most cases, that's not a problem because the rent is reimbursed if you have a GMS or a PMS contract. But it's only reimbursed so long as that PMS or GMS contract remains in place. When people talk about risk in a GP practice, they are almost always talking about the risk of the practice packing up, things coming to an end. So long as the practice continues, there isn't very much risk. You're heavily insured. Your rent is paid, either notional rent is paid or there's a rental reimbursement. It's only when the practice comes to an end, when the GMS or PMS contract ends, the contract's handed back, that then costs can arise, either because you've got to wind up the practice, pay off the staff, pay the rent for the remainder of the term, or if you own the building, it goes down in value because there's no longer a GP practice in it. So when people talk about risk, they're talking about what happens at the end if the thing goes pop. And so I don't agree that there's no risk in a lease because the rent is reimbursed, because if the practice goes pop, then the rent is no longer reimbursed and you've still got to pay the rent to the landlord. In that situation, if the practice does go pop, we'll talk about this later on again, but there's no duty for NHS England or the CCG or the local health board to step in. In many cases they will. In many cases they will, but there's no duty on them to do so. They will do so out of pragmatism if it suits them. And so I think it's worth putting younger GPs right about this, that there's no risk in joining a leasehold practice. And a further point to make, which I've done in a crude graph form on the next slide, Tomar. You might want to show them this if you're making this point to them. On the right-hand side, you're in a building that you don't own, and there is just liability under the lease. And if the practice goes pop, you have to pay off the rent. It's just a big red liability. On the left-hand side, if you're in a freehold practice, then if all things being equal, if the worst comes to the worst, you sell the building and use the proceeds to pay off the loan. Now, everyone takes their own view, but I would rather be on the left-hand side of that equation. Nonetheless, moving on to the next slide, over the past years, there have been plenty of new partners who've been reluctant to buy into buildings. And because practices have been so keen to take on new partners, many practices have allowed in the non-property owning partner. Now, there's nothing illegal about it. It's perfectly permissible for the partners to own the building in different shares, or indeed to not own the building at all. But it's the sort of situation that I'm very keen that partners don't go into with their eyes closed, because the problems that it gives rise to aren't always immediately apparent, but they become apparent over time. And we now deal with lots of problems that arise because these decisions were taken 5, 10 or more years ago. So why can you get problems from having non-property owning partners? Well, the first thing is it can lead to splits within the partnership because the partners have different incentives, different financial interests. If the building needs repairing, then the non-property owners will be jumping up and down saying, repair the roof, repair the roof. The roof is letting in water. And the property owners will also be thinking, well, we need to repair the roof because it's letting in water. But it's going to cost us quite a lot of money. So could we get away with a sticking plaster for 2 years? And the two different sides will see it in different ways, and it can be the start of splits within the partnership. Naturally, for the same reason, there can be disagreements about how costs are borne. Who should pay for this? Should it be the partnership? Should it be just the property owners? And increasingly, one sees resentment from the property owners about the fact that they're protecting the non-property owners from risk. A non-property owning partner is in a really charmed position in a way, because they are a GP partner, a principal, and yet they don't have to take risk under a lease, and they don't have to take risk under a bank loan either. Rather a good position to be in. And a property owner might say, this isn't fair. I'm taking risk and reward in the practice's main asset, and you share none of this risk despite having the same status as me. And the non-property owner might reply, well, yeah, but you're getting the notional rent, so you take the reward for the risk that you're running. To which the property owner might reply, well, yeah, but you obviously don't think it's enough of a reward for the risk I'm taking, otherwise you would take it yourself. So you can get, as I say, resentment from one partner who is taking risk that his partner in the next room won't take. But the really big one is that it sets a precedent. If you take on one non-property owner, you might have to take on another and another and another. And there's a diminishing number of property owning partners. What happens when the last property owner retires? Well, things get very difficult. You get into very difficult negotiations at that point. So as I say, it's not illegal, but it can give rise to disputes, and it shouldn't be done. It shouldn't be done lightly. Now, on the next slide, the flip side of that, of course, the flip side of people not wanting to buy in is that sometimes retired partners want to or are allowed to retain ownership of the building even after they retired. Again, this is the sort of thing which can seem like a good idea until you look a bit more closely at the detail. Again, with retired property owner, so someone who's no longer a partner but still owns a share of the building, you can get disagreements about how costs are borne, obviously. Now that can be dealt with if there's a proper document in place, but the detail needs to be worked through and negotiated. It's not always as good for a retired partner as they might initially think, because it's certainly less tax efficient when the retired partner eventually comes to sell. If they sell when they retire, they pay less capital gains tax. They pay, at the moment, it would be 10% CGT, whereas if you sell more than 3 years later, you pay CGT at the higher rate of 20%. So that's not great. There's also stamp duty land tax to pay, because transfers between partners don't attract SDLT. But once you transfer a share of a partnership asset outside the partnership, there is SDLT to pay on that transfer, and then from any transfer from the retired partner to anyone else is going to attract stamp duty land tax. It's also difficult having a retired partner as a co-owner of your asset. They may be difficult about things like particularly new developments or extensions. They may want to veto those, and they will have a veto so long as they remain an owner. You may need their signature on things, on leases or subleases or refinances, and retired partners have a habit of not being very available. They're enjoying their retirement, of course. Or they may refuse to sign things because there's been some dispute about the final account, or there's been some sort of falling out. But the main thing is that a retired partner, again, doesn't have the same financial interest as the others, and quite understandably wants to maximise their income from the assets to fund their retirement, and so they're less likely to want to spend money on maintaining the premises, etc. So they're not the ideal co-owner. It's also, almost always a breach of the bank's terms. If there's a mortgage in place, then banks will lend. Many banks will lend 100% of the 100% of the value of the building, because the GPs are owner occupiers and in receipt of notional rent. But once you get a third party, like a retired partner, owning a share of the building, that can tick different boxes for the bank, and they may well say, well, hang on, we lent you 100% at a low rate because you were all GPs who had access to the notional rent. At least one of you is now an investor, so we want to renegotiate the terms of the loan. So that's not just a problem for the retired partner, it's a problem for everyone. And lastly, on this subject, a negative of having a retired property owner is that he or she is no longer in the partnership, so the partnership deed doesn't work anymore for them. You need a separate document which sets out how you make decisions and what happens if someone wants to sell or someone dies or whatever it is. So you need a separate property owning partnership deed, which means legal fees. So lots of negatives to having retired partners. Again, not illegal. It can be done, but often it's not as good as it seems at first glance. Moving on to the next slide, I've talked about property owners and non-property owners. When do you need to put a lease in place? Well, I'll deal with the easy answers first. The easiest answer is on the left-hand side. You see the fried egg sort of picture. If all of the partners, if all of the property owners are within the partnership, so everyone who owns the building is a partner, even if some don't, you don't need a lease. I've seen some solicitors say that if not all of the partners own the building, then there should be a lease from the property owners to the partnership. Don't agree with that at all. It's easy in that situation on the left-hand side, to deal with all the provisions in the partnership agreement itself. Then we have the situation on the right-hand side, where ownership of the building and partnership has totally split. So everyone who owns is left, and no one who has joined the partnership has bought in. In that situation, you have to have a lease. Very simple. There's a total split between landlord and tenant. But then there's this slightly more complicated situation in the middle, the Venn diagram, where some partners own, some haven't bought in, and some retired partners continue to own. Now, in that situation, you may be able to get away without a lease. And by the way, it's always worth doing without a lease if you possibly can, because leases are a pain, they're expensive, they need to be negotiated. So perhaps in the middle, you don't need a lease, you could just have a property owning partnership deed. But those retired partners are very reliant on the ones in the middle of the Venn diagram to hand over the notional rent to them. And if those in the middle of the Venn diagram suddenly disappear, go under a bus or retire themselves, then suddenly you're in the situation on the right. But you don't want to get into the situation on the right without a lease, because it's much, much harder to negotiate it when you're already in that situation. You need the lease in place before you have that separation. So what's the right time to put a lease in place? Well, it's before you end up in the situation on the right. And clearly, when you're in the Venn diagram situation, you can quite easily end up in the situation on the right sooner than you thought, because someone retires earlier than planned, or dies, or there's a dispute, or whatever it is. But best to get away without leases if you can. Now, on the next slide, I've got the next few slides is about a dispute with a type of dispute that we're seeing a lot of at the moment, which is disputes about valuations of the premises. Really important, if you're a freehold building, that you have a clear clause on the approach to valuation when a partner retires. What if you don't have such a clause, or if you do have such a clause but your partnership deed doesn't bind anyone anymore? Well, what can often happen is quite unpleasant disputes about the price, the value of the building, what the retired partner is entitled to when he or she sells out. Now, this isn't a new thing, but what is new is that over the past few years, a minority of valuers have started to take a slightly different approach to valuation. I'm not saying these valuers aren't expert, but there are a minority of them who have started to take a different approach. And that approach is to assume that a lease is in place when in fact it isn't. I don't really need to go into the details of that in this presentation, and we've written articles about it anyway, which are available. on request. But if you assume a lease is in place, it drives up the value of the building. What tends to happen if the partnership agreement isn't clear is that a retired partner can go off to possibly one of these valuers who will produce what I would describe as an inflated valuation. And once the retired partner gets that, he or she always takes it to heart. This is the only possible valuation that can be right. And anyone who wants to pay me less than this is doing me out of my rightful retirement pot. Whereas the continuing partners are being told by their valuer and by the bank, no, that inflated valuation isn't right. It's worth this. And the number, often those two numbers are a long way apart, and it's really worth both sides spending quite a lot of money on lawyers to argue about it. It certainly leaves the practice stuck in the middle, because if they can't make the retiring partner sell, and the retiring partner is asking for more than they can afford, what are they supposed to do? Well, what they're supposed to do is not get into the situation in the first place, have a binding deed, and that is absolutely clear about retirement valuations. So if you've got that sort of dispute, don't start from here. But what if you do have that sort of dispute? Well, I've got a case study about it on the next slide, Taylor. This is, well, as I say, we've had several disputes like this over the past few years, where a retired partner decides that they want to retain a share of the building because they decide that they're much better off having a share of the notional rent than having their money in the bank earning next to no interest. But the other partners want them to sell. Now, if the partnership deed is unhelpful here, then it just comes down to a negotiation, and it's really hard for either side to force the other to do anything. As I've already said, it's not great for the practice as a whole having a retired partner as an owner, because they tend to just want to maximise their income from the asset rather than keeping things in the best order they can be. So what do you do? Well, next slide. The first thing you always try in this situation is say some of the things to the retired partner that I've said so far in this session. Persuade the retiring partner that it's not actually a very good idea to hang on to the building. There's SDLT to pay on the transfer out of your share in the partnership asset. You will lose entrepreneurs relief. I've already mentioned that you pay capital gains tax at a higher rate. It talks about it being a breach of the bank's terms. Someone's got to pay for a new property owner's deed. Who's going to pay for that? Presumably the continuing partners won't want to. And depending on how things stand, going back to my earlier slide, there might be a lease that needs to be put in place. As I said, leases are a pain. They're very necessary when they're necessary, but it means legal fees. Depending on the terms, it might mean more stamp duty, land tax. Usually there's a long negotiation to be had over what the terms should say and how long the lease should be, etc., etc. And you need to get NHS England's consent or the Commissioner's consent to the lease before it's put in place. So it's a bit of it's a pain. Now, you start by making those sorts of points to the retired partner, but if they're still not persuaded, where do you go then? Well, next slide. In a couple of these cases that I'm thinking about, it depends very much on the facts. It depends on what the partnership agreement says and whether there's anything else in place. But often, if the partnership deed doesn't say that the retired partner has to sell, it also won't say anything about having to pay notional rent to the retired partner. And a retired partner who continues to own the building won't, as of right, necessarily have a right to be paid the notional rent. The notional rent gets paid to the partnership. Does the partnership have to pay it on to the retired partner? Not unless a document says so. And if you're in that position, then one of the options open to practice is to say to the retired partner, well, if you're not selling out to us, fine, but we're not handing the notional rent over to you, which certainly increases the temperature of the dispute, but can be quite useful. Now, arguments can be made the other way. And the retired partner can say, well, I'm entitled to an account of rent, which is an equitable remedy. Is he entitled to an account of rent? Maybe. Only a court can really decide. But even withholding that rent and saying, sue us, is quite a good way of showing someone in that situation that perhaps they haven't got the best investment here. If they have a building with a tenant in it, but the tenant can't be made to pay the rent without being taken to court. All depends on the facts, but as I say, we've had quite a few of these over the past couple of years. And best thing to do, have the partnership deed, put it beyond doubt, so you don't get into this sort of expensive situation. Excuse me again. Next slide, please, Tamar. Primary care is always getting mucked around with and adjusted, and a lot of those changes need to be reflected in partnership deeds. So if you haven't updated your partnership deed for the last 2 or 3 years, these are the sorts of things that you ought to think about putting in. Final pay control clauses, only relevant now where there are non-GP partners, but some practices have been stung very large sums because of having non-GP partners who retired and their pay went up over a certain threshold. You need a clause to protect you against that. Most partnership agreements, not just GP partnership agreements, will feature cross options when a partner retires. So rather than saying the continuing partners will pay out the retired partner, they will say the continuing partners have an option to buy and the retired partner has an option to sell. This is because of a tax point that no longer applies. The problem with options is that very often people don't know about them and forget to serve them. And then you end up in the position I've just talked about, where because the option wasn't served, you can't make the retiring partner sell, and you're in that difficult negotiation position. So time, in my view, to get rid of cross options, and I'm not using them anymore, except sometimes in last man standing clauses. Sick leave clauses. Most GP partnership agreements will say that after someone's been away for 12 months, they can be asked to retire. Problem is that discrimination law trumps whatever is in the partnership agreement. And if you've been off sick for 12 months, you're very likely to have a disability of some sort. And so you can argue that you're being discriminated against illegally by being asked to leave after 12 months. As I say, nothing in the deed, there's nothing we can put in the deed which is going to change that. But certainly if you get into that sort of situation, you want to make sure that no one is able to draw a profit share after 12 months. Otherwise, during the period that you argue about whether someone is being discriminated against or not, and whether they should be made to retire, you still may be paying them, you still may be being obliged to pay them a profit share, which is quite unhelpful. PCNs and state-backed indemnity, there are provisions which need to be added to reflect those. And then last man standing clauses I wanted to talk about. Moving on, Tamar, you always get more focus on the last man standing issue when recruitment is difficult. And so I've been having fewer conversations about this in the last 12 months, but it's still out there, of course. The question is, what happens if the last man or last partner standing wants to hand back the contract? Well, the worst case scenario is that he or she would have to pay all the winding up costs to the practice, him or herself, and absorb any premises costs, him or herself. It's worth stressing that is really very, very rare. And I'll talk about that on the next slide. But for those practices who are concerned about partners leaving in sequence, leaving a last partner standing, the alternative is to have a last man standing clause, which says that when a partner retires, the others have a choice. So if you've got partners A, B, C, and D, and partner A decides to retire, the other partners have a choice between either buying partner A out in the normal way refusing to carry on a loan and saying we're going to wind up the practice and share the cost 4 ways. That's a last man standing clause. As I say on the next slide, there are downsides to the last man standing clause. Yes, it does reduce the risk a little bit for the youngest partner having such a clause, but it doesn't make the risk go away. It just spreads it among the other partners. So it spreads that uncertainty much more widely amongst the others. And that can become a self-fulfilling prophecy in a way. You can precipitate the collapse that you're trying to avoid. Because if I'm partner A who's about to retire and I'm pessimistic about how things are going in the next couple of years, I might say to myself, if I retire now, I think they'll buy me out. If I retire in 2 years, they might not. They might wind up the practice and involve me in the costs of that. So I think I'll get out now. So you could actually bring forward the retirements that you're concerned about. Another objection to last man standing clauses is that if they're activated, you'll never know whether that was unnecessary. I have seen many situations where a practice has gone down to 2 or 1 partner. They've turned it around, put the practice back on a stable footing, and everything's been fine. If the last man standing clause is activated, you'll never know whether that might have been the case. And so there are those negatives to having a last man standing clause, the spreading of uncertainty, which can become a self-fulfilling prophecy. And I just wonder if they actually provide that much comfort for younger partners when you really think about it. Would it give me, as an incoming partner, much comfort to be told that in the worst case scenario, I won't have to bear all of the winding up costs. I'll only bear a half or a third of them. I'm not sure how much comfort that really is. Everyone sees things differently, of course, and one has to think these through. And as I say, these will be appropriate for some practices, but not others. But if we move on to this next slide, I'm not going to talk to this in detail, but it's there in your packs. It's worth thinking about what the worst case scenario actually is. It might not be as bad as the partners often assume. If you are in one of these, I would say the majority of practices are occupying a building where if they handed back the contract, the commissioner would have no choice but to put a caretaker practice into that building to run the practice instead. There's no guarantees, but I think it's a minority of practices where the commissioner could genuinely disperse the list. Now, if you're in that situation where your building has to be used and a caretaker practice comes in because you've handed back the keys, then all the staff are going to transfer by GP to the caretaker provider. So there's no redundancy to pay, and the building will be occupied. So there'll be someone there to pay the lease or help pay the bank loan. It's a rocky situation to be in, but it's quite feasible that there are no costs for a last man standing or last partners standing in that situation. So in that situation, if you're in that situation, I would suggest that perhaps a last man standing clause isn't appropriate because your worst case scenario isn't that bad, and there's no need to create the extra uncertainty that goes with a last man standing clause. Anyway, one can only talk in general terms here because there will be different scenarios in every practice. But it's off the point of my flowchart there is that it's often not as bad as it seems. Right, last slide, Tamar, before I take some questions, if there are any. Non-GP partners. Well, as I said, we've seen loads of new partners joining recently who aren't GPs. No legal problem with that. As long as one partner is a GP, then there is no limit to the amount of non-GP partners you can have. Obviously, it's slightly worrying if there's only one GP, because if he goes under a bus, then all the other partners can no longer validly hold their GMS or PMS contract. But that aside, the only real issue is that the partnership agreement needs a few tweaks to reflect the non-GP partner status. Not difficult, but needs to be done. For example, the clause that says thou shalt be registered at all times with the GMC, and if not, you can be expelled. Clearly, that's no longer appropriate for non-GPs, and so that has to be tweaked. But the real two issues to think about are voting. Do non-GP partners get an equal vote? Different people will come to different conclusions on this. My view is that yes, they should have an equal vote. They're taking on joint and several liability for the practice. They're liable for the decisions made, so they should have an equal say in those decisions. I always think it's difficult in a small business situation if you sit around the table as equals, but one or more of you have opinions that are more valid than others. I don't think that's helpful for the partnership relationship. Sometimes I get asked to put in clauses that say that non-GP partners don't have votes on clinical matters, purely clinical matters. And that always seems a bit artificial to me, because is there really anything that is purely clinical that gets voted on, that has no business impact at all? Perhaps there is. But the really big one is profit sharing. How do you account for, how do you value the input of a non-GP partner? What profit share are they going to have? It's always been so easy with GPs, hasn't it? They all do the same or much the same job. And in fact, the existence of the goodwill rules means that probably they have to share profits equally, pro rata sessions. Anyway, so there's been nothing to rethink about. But what about non-GPs? Do you value them the same? How do you value them? I'm afraid I don't have a good answer for you, except to say that there is no good answer. I've seen some people, I've seen another solicitor say that they reckon it's somewhere between, a non-GP should get between 55 and 75% of a full partner's share. I've seen no evidence of that in the jobs that I've done. Using managing partners, practice managers who step up to partnership as an example, I've seen the whole gamut. I've seen PMs get a fixed share equivalent to the salary they had before, and I've seen a two-partner practice, one GP and one managing partner on an equal 50-50 share, and I've seen everything in the middle. I can't see a thread running through it. I can't see a norm. And I'm afraid it just comes down entirely to the bargaining position and the negotiating skills of the parties involved. So there's an unhelpful point to end on. But I'm now going to look and see if I've got any questions. I've got 3 questions. We know that dissolution of a GMS partnership at will leads automatically to contract termination, as the entity that holds the GMS contract is the partnership, correct? What is the legal position when a PMS partnership at will is dissolved? We have heard conflicting views from different legal firms. Thanks very much for the curveball. Yes, I always think it's one of these difficult areas of advising on the NHS, where the law might say this, but NHS reality is slightly over here. In reality, a commissioner will do everything possible to put pressure on the parties to agree that actually there was no dissolution after all, to save them putting the contract out to tender. I have seen so few contracts go out to tender in my 15 years doing this. Look, I take the view that very strictly, a PMS contract and a GMS contract aren't the same things. A PMS contract is held by the partners individually. It's not held by the partnership. A partnership cannot hold a PMS contract, only the individuals. And therefore, if the individuals may dissolve their partnership, but that doesn't send the contract out to tender. That's my view. Very happy to engage in that one further if you'd like to pick that up. As indeed is the case for all of this. Anyone who would like to talk about things further, my contact details are on the slides. Would you advise that in a freehold building, all new partners buy into the building to ensure there are no NPOs? Yeah, I think that's best practice. I know it's easy for me to say, isn't it? And I'm not the one who's struggling to recruit new willing property owners. But yes, I do think it's for the best interests of the partnership that all the partners are in the same boat and have the same financial motivations. Otherwise, you're just creating issues which over time will get worse. Next question, do you have to pay SDLT on new leases? New partnership deed done, but property is leased, so new partners' names on new lease. Well, this isn't my area, and I have others in my team who know more about this. But my understanding is that with a new lease, SDLT is payable depending on the terms of it. So the longer the lease and the more the rent, the more likely you are to pay SDLT. There's a threshold which is reached where you have to start to pay. Some of, I don't know if this is relevant to this particular question, but many practices have been doing sale and lease backs in the last few years, where you sell the building to an investor and take a lease back from the investor. So you convert from a freehold to a leasehold practice and take all your money out, you sell the bricks and mortar as you do. Now in that situation, I understand that there's an exemption so that you don't pay SDLT if the seller and the person who takes the lease is one and the same. But it depends on the facts and depends on the terms, and we'd be very happy to discuss that. And the last question I've got here, with regards to the valuation, it's not my last, this is another one. With regards to the valuation, I understood that there was a formula that surveyors had to follow, possibly specified by the Institute of Surveyors or whatever they're called. Yes, you're absolutely right, there is. The RICS, Royal Institute of Chartered Surveyors, has guidance for expert valuers, and all expert valuers will be aware of it. And I always say in my partnership deeds that any valuation must be based on, the valuer must follow the guidance issued by the RICS. The problem is that different valuers have started to interpret this differently. I personally, it's difficult for me to say too much about this because I'm a mere lawyer and not a surveyor. But the RICS valuation guidance says that they should assume vacant possession. So they can take account of the fact that a notional rent will continue to be paid, but they should assume vacant possession. Now, to me, that seems inconsistent with saying that a lease is in place. How can there be a lease and vacant possession? Well, you'd have to ask different valuers about that. As I say, it's only a minority of the valuers who are creating these inflated prices by saying that they're assuming a lease, and all the other valuers, from what I can make out, say that they're absolutely wrong. Anyway, you can put the point beyond doubt, as I say, by having something in your partnership deed saying, do not assume a lease, and then the problem goes away. And then my last question, I've got 3 minutes left. Thank you for your question. If you can't enforce the probation with a new joining partner, how would you suggest handling it? Well, what you do is get the new partner to sign the new partnership deed on or before the date they join. And then if the partnership deed includes a probationary clause, which it should do, then you are covered during that probation. You only can't enforce the probation if you haven't had the partnership agreement signed. So get the partnership agreement signed on or before the day the new partner joins. And as I say, that doesn't need to be a big undertaking. You don't have to incur legal fees on doing that. You can just take your old partnership agreement, change the names, and sign it again. Of course, I'd be delighted if you came to me to update it, but if you're in a hurry, just sign the old deed again, and then at least there's something in place until, at least there's something in place during that probation.